The matter is TH versus CH, all the way from the Western Cape High Court, ZAWCHC 100, 2024, safely reference, under the pen of Nziweni J. Judgment landed 9 April 2024, can be found in your bundle, pages 220 to 246. So for those of you who are in the bundle, please forgive the jump. I had a little bit of an issue with my Adobe getting all the judgments compiled, and this one had to slot in right at the end. That's page 19 on your summaries bundle. So essentially, it was an application regarding PRR in terms of the TH, who's the applicant, the father, and CH, the respondent mother, post-divorce. There were concerns centering around the mother's ability to act in the best interest of the child due to temperament, substance abuse, and alleged physical and emotional abuse of the child. Expert reports were taken into account. There was I believe it was a clinical psychologist, or a psychologist certainly, who evaluated did the assessment. The court evaluated their reports. What was interesting here, if my memory serves, the primary residence was with mom post-divorce. That got flipped around after an incident of abuse towards the child, and now this matter then eventually reached the High Court after an investigation. What was interesting in this judgment, what you need to be aware of, is the court looked at 4 different phases of phased-in contact as recommended by the investigator. It's interesting to see how those aspects were formulated by the court. And the court then obviously, as in all cases with kids, looked at Section 7 of the Children's Act and Section 28(2) of the Constitution, which are our go-tos when talking about best interests of the child. What is interesting, paragraph 23, it's tried that although parental rights are expressly protected in the Children's Act, they are not by any stretch of the imagination absolute. I find it interesting, this wording. I don't think it's wrong per se, but parental rights are expressly protected in the Children's Act. Now, in South Africa, we do not distinguish between parental responsibilities and rights. That is one parcel. As an interesting aside, in jurisdictions like Scotland, for example, you have parental rights under one section of legislation, parental responsibilities under a different section. In South Africa, we make no distinction. So speaking about parental rights without using the full term parental responsibilities and rights feels a bit strange. And it's interesting that the court talks about these rights being expressly protected. I think they are specifically defined in Section 18.2 or Section 18, Section 18.2 and Section 1.1 in terms of the definitions. But I think the exercise vis-a-vis the child is much more of a child-centric approach than simply the parties' rights being protected. I'd love to hear your comments on that. However, very sound judgment by Nziweni J in terms of the outcome, where he says a proven failure by a parent to manifest willingness and ability to act in the best interest of the child may lead to termination or limitation. What happened here? There was phased-in contact that was ordered, safeguards implemented in terms of drug tests, etc. for mom. Parenting coordinator was appointed, and each party was ordered to pay their own costs. So, folks, final stretch today. We've got 4 more judgments to go: 2 contempt of court, 1 foreign marriage, and closing off with the surrogacy matter from the SCA. This, however, was TH versus CH, ZA, Western Cape High Court 100 and 2024, and that is safely referenced under the pen of Nziweni AJ on 9 April 2024.